In this video, we will begin our look at the seller's remedies in the event of the buyer's breach by focusing in on the scenario where the seller has tendered and the buyer has possession of the goods. Where a breaching buyer has the goods, it is typically because the buyer has accepted the goods but has refused to pay the seller for those goods. Where the buyer has accepted the goods, but the buyer has refused to pay as required under the party's contract, that is the most straightforward scenario for the buyer to breach. It is also the most straightforward scenario for determining the seller's remedies. Section 709, subsection 1A, sets forth the seller's primary remedy where the buyer has accepted the goods but has failed to pay or refused to pay the seller. In that scenario, the seller's primary remedy is the contract price for the goods. And that makes good sense from the perspective of protecting the seller's expectation interest. After all, upon acceptance, the buyer was obligated to pay the seller the contract price for the goods. And where the buyer breaches that obligation, then to put the seller in the position that she expected to be had the contract been fully performed means that the seller must get the contract price for the goods, the price that she expected to receive from the buyer under the breached contract. So, under 709 subsection 1A, recovery of the contract price is the seller's remedy. Recovery of the contract price is the measure of the seller's direct damages. In addition, as we will discuss later in this module, under section 710 of Article 2, the seller may also be entitled to indirect damages. Specifically, the seller may also be entitled to damages for her incidental losses. But that's something that we will come back to later in this module. For now, the important thing to note is that the seller's basic remedy if the buyer has accepted the goods is the contract price for those goods plus the seller's incidental damages. From the seller's perspective, the right to collect damages is nice, but it is a right that is only as good as the buyer's ability to pay a judgment for damages. If the buyer is unable to pay, that is, if the buyer is insolvent or in bankruptcy, then the remedy of damages is effectively worthless for the non-breaching seller. Therefore, instead of a judgment for damages, the seller might simply prefer to take back the goods that the breaching buyer has in its possession. Unfortunately for the seller, where the buyer already has the seller's goods, the seller is generally not entitled to take back or repossess those goods. We must say generally, however, because there are two exceptions, two limited situations where the seller does have the right to repossess its goods that the breaching buyer has in its possession. The first exception is where the seller has a contractual right to repossess the goods because the seller retained a security interest in the goods that are in the breaching buyer's possession. That is, in the original contract between the buyer and the seller, which contemplated the seller would deliver the goods to the buyer before the buyer was to pay the seller, the parties also agreed that the seller retains a security interest in those goods. Where the seller retains a security interest in the goods being sold to the buyer on credit, the goods being sold to the buyer become collateral for the buyer's obligation to pay the seller for those goods. Stated differently, if the buyer fails to pay the amounts it is obligated to pay the seller has a contractual right, as a secured creditor of the buyer, to repossess the collateral securing its right to payment. As we said, a security interest is something that is created pursuant to a contractual agreement between the buyer and the seller. Otherwise, the creation of a security interest and the rights and remedies of a secured creditor thereunder are covered by Article 9 of the UCC, not Article 2, and therefore beyond the scope of our course. The second exception where the seller may have a legal right to repossess the goods that are in the hands of a breaching buyer is found in Article 2. Article 2 provides that in limited situations, the seller may have a legal right to reclaim the goods that are in the buyer's possession. The seller's right to reclaim the goods applies in two limited situations. The first situation arises under Section 507, subsection 2. 507 is another example of Article 2's less than perfect statutory drafting. The plain language of subsection 2 does not make this very clear, but as the reading explains, under subsection 2 of 507, if the party's contract requires the buyer to pay the seller upon the seller's delivery of the goods, such that payment is due upon delivery and before the buyer's inspection or acceptance of the goods, what is sometimes called a cash sale transaction, then the buyer does not have any rights to the goods unless the buyer pays. To paraphrase the language of the statute, the buyer's right to retain the goods is conditioned upon the buyer actually paying the seller. So when the party's contract requires the buyer to pay upon delivery, the buyer's rights to the goods is conditional upon the buyer's payment to the seller. The circumstances where this right to reclamation might apply are quite limited. Imagine, for example, the seller delivers goods to the buyer. Under the party's contract, the buyer is obligated to pay upon delivery. The buyer pays the seller, but pays by check. The seller takes the check and leaves the goods with the buyer, but then later, the buyer's check bounces. It fails to clear. In that very particular situation, the buyer has not actually paid the seller as required by their contract, but the buyer has the goods. So under subsection 2 of 507, the seller is entitled to reclaim those goods. Note how narrow seller's right to reclamation under 507 subsection 2 is. It does not apply where the buyer pays the seller in cash rather than by check. Likewise, it does not apply where the party's contract contemplates that the buyer will pay the seller sometime later, after the seller delivers. Nor does it apply where the party's contract requires the buyer to prepay for the goods before the seller delivers. 507 subsection 2 applies only in the very narrow circumstances where the party's contract requires payment due upon delivery and the buyer somehow fails to actually pay for the goods. The second limited circumstance where the seller might reclaim the goods that are in the hands of the breaching buyer arises under section 702 subsection 2. This subsection applies only if the buyer is insolvent when the buyer received the goods from the seller. So imagine that pursuant to the party's contract, the goods have been sold to the buyer on credit. That is, the buyer is not obligated to pay for the goods until some time later, after the buyer has inspected and accepted the goods. If the seller learns sometime after delivery that the buyer was insolvent when the buyer actually received the goods from the seller, then the seller has 10 days from the date of delivery to give notice of its intent to reclaim. Note again how narrow the seller's right to reclamation is under section 702 subsection 2. It applies only where the buyer is insolvent at the time the goods are delivered. It does not apply if the buyer becomes insolvent at some later time, at any time after the goods are received by the buyer. In either case, where the seller has a legal right under Article 2 to repossess the goods that are in the breaching buyer's possession, simply because the seller has that legal right does not mean the seller can resort to self-help or extrajudicial vigilante justice. Stated differently, the seller cannot decide to forcibly break into the buyer's premises to retake its goods from the buyer. If the buyer won't voluntarily relinquish the goods, the seller must seek to reclaim those goods through a judicial process. The upshot of all of this is that because the legal right to reclaim under Article 2 is so limited, a seller that is selling goods on credit is much better off retaining a security interest in those goods pursuant to UCC Article 9. So in this video, we covered the remedies available to the seller when the buyer has the seller's goods and has breached its obligation to pay the seller. Those remedies include, as we noted, the right of the seller to seek damages against the buyer for the contract price of the goods, plus any indirect incidental losses that the seller might suffer. Or alternatively, under very limited circumstances, the seller might have the right to reclaim the goods, to take back the goods from the breaching buyer. In the next 3 videos, we will take up the question of the seller's remedies in the situation where the buyer breaches before the goods have been delivered to the buyer, where the goods are still in the possession of the seller.